Hello, this is Lieutenant Tom Fodskar with the Rochester Police Department, and this is a community notification for a registered offender who was civilly committed who is now being released to Rochester. Today we will cover registration and the risk levels, the Community Notification Act and the Minnesota Sex Offender Program. We will discuss the offender who is being released, Dale William Hodge, and we will give you a list of resources. Registrants and those with a history of committing sex offenses have always lived in our communities, and it's likely that they live, work, and interact every day in communities in Minnesota. Minnesota's predatory registration law was established in 1991. The program is administered by the Minnesota Bureau of Criminal Apprehension, and the contents of the registration are addresses, employment, school, and job information and vehicles for offenders. As of January 2021, there were approximately 18,727 people required to register in the state of Minnesota. As of September 27th, 2021, there were 395 registrants in Olmsted County, 340 in Rochester, and as you can see on the screen, the numbers for the surrounding counties. Registration is required if an individual is convicted, charged, or adjudicated delinquent for specific crimes: criminal sexual conduct, any sexual conduct involving a minor, including possession of child pornography, kidnapping, and false imprisonment. Established in 1997, the Community Notification Act allowed for broad public notification for Level 3 offenders, and for those from other states or federal jurisdictions who were released from prison, and those released from the MSOP on a provisional discharge for a period of 4 years. At that time, if not a Level 3, broad community notification isn't required if supported by the MSOP Executive Director. Let's go through the risk levels now. Level 1 is considered a lower risk, and under a Level 1, law enforcement may notify other law enforcement agencies of the offender's information. Law enforcement shall notify victims and witnesses of the offense, and law enforcement shall notify adult household members living with the registrant. Level 2 is labeled a moderate risk. In addition to all the requirements for notification on from Level 1, law enforcement may notify individuals or organizations based on the registrant's particular offense pattern or history. Level 3 is considered a higher risk, and those Level 3 offenders are subject to broad public notification. They are listed on the Department of Corrections public registrant website. Community notification educational meetings are done. Their information can be released to the media, newspaper, radio, and television. They can be posted on agencies' websites, on social media, and can also be distributed through door-to-door flyers. As of September 27th, 2021, there were 460 registrants subject to broad public notification in Minnesota. 10 of them in Olmsted County, 8 in Rochester, and you can see on there the numbers for our surrounding counties.
Hi, my name is Nancy Johnston, and I'm the Executive Director of the Minnesota Sex Offender Program. Today, I'm going to talk with you about civil commitment in our state, as well as Mr. Dale Hodge, who will soon be released on a provisional discharge into the Rochester community. Minnesota has a civil commitment program for sexual offenders, as do 19 other states in the country. Approximately 15 to 20 people are civilly committed every year out of approximately 1,100 registered sex offenders who are released from prison or jail every year. Most civilly committed people have already served prison sentences when they are civilly committed to the Department of Human Services. When a person is nearing his release date from prison, the Department of Corrections might send a referral to the county that the client came from. If the county attorney chooses to petition for civil commitment, he or she may do so, and when the person is released from prison, they would then come to the Minnesota Sex Offender Program on hold status while the court process plays out, which takes about 6 months. County courts then indeterminately commit people as a sexual dangerous person and or sexual psychopathic personality. Those are the two statutes in our state. Only the court has the authority to civilly commit people. The program is administered by the Department of Human Services. MSOP is a treatment program, not a prison. Clients' rights are restored once out of prison and with the Department of Human Services. There are two locations, one in Moose Lake and one in St. Peter. The facilities are about 3.5 hours apart. There are two buildings behind a secure perimeter at Moose Lake, and there are two buildings behind a secure perimeter in St. Peter. Outside of the secure perimeter, on the same campus in St. Peter, is our transitional program called Community Preparation Services. It is an unlocked, less restrictive step-down part of our program as individuals prepare for reintegration and reentry into society. Mr. Hodge has been living at Community Preparation Services. There are 3 phases of treatment that clients participate in. It involves core groups or process groups, individual therapy, and psychoeducational modules. Comprehensive programming includes health services, therapeutic recreation, spiritual, vocational, and educational. When a client is in treatment at MSOP, he may petition for a reduction in custody, and there are 3 types. One is a transfer out of the secure facility to Community Preparation Services. One is for a provisional discharge into the community. And lastly, a full discharge from civil commitment. Those petitions go to a 3-judge panel. The 3-judge panel, called Civil Commitment Appeals Panel, has the authority to grant or deny the petition for reduction in custody. If a provisional discharge is granted, the client then is released into the community on a provisional discharge plan and very close supervision. The Department of Human Services Commissioner or the county or the client can appeal to the Minnesota Court of Appeals or even to the Supreme Court of Minnesota if they disagree with the ruling. In order to be provisionally discharged, the client must meet these 2 standards out of the Minnesota Statute 253D.30. The committed person's course of treatment and present mental status indicate there is no longer a need for treatment and supervision in the current setting, and the conditions of the provisional discharge plan will provide a reasonable degree of protection to the public and will enable the committed person to adjust successfully to the community. If he meets those two criteria, the 3-judge panel will grant the reduction in custody. Mr. Dale William Hodge will be provisionally discharged. He is a risk level 3. Mr. Hodge is 63 years old. He's 5'9", 200 pounds, blue eyes, and bald. The residence area is 2100 block of Campus Drive, Southeast Rochester. Mr. Hodge's offense history includes the following. 2007, Olmsted County, the client exposed his genitals in public. He received a felony criminal sexual conduct 5th degree and misdemeanor indecent exposure convictions. 2006, in Goodhue County, the client exposed his genitals in public. He received a gross misdemeanor indecent exposure conviction. 2005, Dakota County, the client exposed his genitals in public twice and received a gross misdemeanor indecent exposure conviction. In 2004, in 2003, and 2001, the client exposed his genitals in public and received a gross misdemeanor indecent exposure conviction each time. All were in Olmsted County. Also in Olmsted County, back in 1991, 1982, and 1979, Klein exposed his genitals in public and received misdemeanor indecent exposure convictions each time. When Mr. Hodge goes out on provisional discharge, he will be closely supervised by MSOP until the point where the court grants him a full discharge from civil commitment. He must follow his court-ordered provisional discharge plan, which includes many conditions of supervision. MSOP has the legal authority to return Mr. Hodge to an MSOP facility at any time if we have concerning behavior to address through a 60-day voluntary return, or MSOP also has the authority to fully revoke release and have Mr. Hodge return to a facility. The provisional discharge is revoked, and he would have to go back through the court system, the court process, to be provisionally discharged once again. Mr. Hodge will be subject to registration for the rest of his life. The role of the reintegration agent is twofold. One, to act as a probation agent, similar to that, and also as a case manager. They manage and supervise very small caseloads of 10 people or less. They conduct random searches, test alcohol and drug use, conduct unannounced visits to work and residences. They manage the global positioning system. Clients wear a bracelet on their ankle at all times, and we can monitor their location passively and actively. The agents oversee the compliance with the court-ordered PD plan, making sure he is following his conditions. They conduct overt and covert surveillance as needed, and most importantly, help the client reacclimate, find a job, secure outpatient treatment programming, and ongoing case planning. There are currently 28 people who are on provisional discharge in the community right now that are supervised. A total of 51 provisional discharge rulings have been granted in the history of the program. No client on provisional discharge has sexually reoffended. Since 2016, there have been 15 people who have been granted a full discharge from civil commitment. The reintegration agent for Mr. Hodge is listed here. His name is Pat Quigley. This concludes my portion of the presentation. Thank you for your attention.
Thank you, Nancy. To contact law enforcement about this or any other matters, please refer to the following numbers. To report suspicious behavior, please call 911. For general inquiries, please call 507-328-6800. On the next few slides, you will see some additional resources. Thank you.